Good afternoon, members. I call the Committee of the Whole on Bill 25, Haida Nation Recognition Amendment Act 2024 to order. We are currently on Clause 2. Shall Clause 2 pass? Recognize the member for Vancouver-Langara.
Thank you, Mr. Chair. And let me just start by saying I appreciate the procedural motions that the Government House Leader just moved in the main chamber prior to restarting this committee process. That whatever discussions the government may have had about Bill 25 were presumably in recognition that any time allocation by government, which they just did to Bill 26 and Bill 27, wouldn't be appropriate given the nature of the discussion we've been having on Bill 25. So I appreciate that the government has not yet imposed time allocation on this bill or brought closure to the committee review of this bill. We will wait to see what happens, the fate of Bill 21, which is another bill that I am hoping to speak to, depending on whether the government gives me the opportunity to do that. I will say that, Mr. Chair, the Minister before the break was referring to Sections 419 and 420 of the agreement and how it is giving guidance, let's say, in terms of how decision-making would be continued through the Reconciliation Protocol as well as the Reconciliation Act to align with Haida Aboriginal title as referred to in the agreement itself. And again, as I noted previously in discussing the agreement, the term Haida Aboriginal title is a combination of reference to well, let me just get a point of clarification on what that refers to, because I know that we touched on this before, Mr. Chair. There's a definition of Aboriginal title in the agreement, and there's a definition of Haida title. There's a definition of Haida Nation, but just for clarity purposes, when the term Haida Aboriginal title is utilized in Section 419 and 420 of the Act, as we're discussing Section 4.4 sub 3 under Clause 2 of Bill 25, can I ask through you, Mr. Chair, to the Minister, what is intended for the term Haida Aboriginal title to mean? Was that meant to use the defined term Haida Nation Aboriginal title?
Minister.
Well, thank you very much, and welcome to the chair. I have for the clerk 2 documents that were handed to me yesterday by the member for Vancouver-Langara. I'll perhaps pass them back through you if that's acceptable. And also I want to recognize the presence in the chamber of Mr. Peter Lanton, who of course is the former president of the Council of the Haida Nation, a member of the board of the Prince Rupert Port Authority, and also again with us is the Premier's Special Counsel on Reconciliation, Mr. Doug White. The question that the member asks relates to definitions contained in the agreement, and the member will know in the definitions section that there are 2 terms, these defined terms with different meanings. One is the term Aboriginal title, and the other is the phrase Haida title. And he asks about those phrases. The Haida Aboriginal title, that phrase, is the Aboriginal title of the Haida. That is to say, it's used in its possessive form. If you will, it defines whose Aboriginal title, the Aboriginal title of the Haida, which is less elegant than simply saying Aboriginal title of the Haida. And so that is what the drafting approach taken in those clauses is meant to convey.
Member.
Thank you, Mr. Chair, and I appreciate the straightforward clarification of the use of the term Haida Aboriginal title. Just from a drafting point of view, from an agreement point of view, what the minister is saying is that obviously it refers to the Haida Nation because that's the party to the agreement. It could have just as easily have said Haida Nation Aboriginal title, but I'll leave it there. 4.4 sub 3, as the minister had previously responded, relates to the overall, speaks in legislative language and certainly recognizes the Section 35 of the Constitution Act 1982. Through you, Mr. Chair, to the minister, by including this provision, recognizing, I will acknowledge 4.4 sub 2, that the enactments of British Columbia in relation to Crown land continue to apply in relation to land that is held by the Haida Nation and Aboriginal title. That provision clearly is there, and I appreciate that. My focus on sub 3 was not to bypass, let's say, sub 2, because it clearly relates to sub 2. But in any event, I would ask through you, Mr. Chair, to the minister, by the inclusion of the for greater certainty language in sub 3, is there anything that is changing in terms of how resource or land management decisions are being made on Haida Gwaii pursuant to 419 and 420? Is there anything greater here contemplated in terms of the recognition of Haida, of the land that is held by Haida Nation and Aboriginal title?
Minister.
Thank you very much. Thank you to the member for the question. The member asked if there's anything changing, et cetera, with respect to his view of 4.4 subsection 3. And in order to answer that, and I did touch on this yesterday, the clause 4.1 that is before us is a clause in which the government of British Columbia recognizes that Haida Nation has Aboriginal title on Haida Gwaii. And so therefore 4.4 sub 3 provides greater certainty that as of now, once the effective date occurs, but in the period before the transition period, is a recognition that enactments that are applied in relation to land on Haida Gwaii take into account the existence of Aboriginal title. And I think that's the symmetry between the two sections in question.
Member.
Thank you, Mr. Chair. I appreciate the manner in which the minister responded to the question. It acknowledges, let's say, Mr. Chair, that even before the transition period starts, that clearly this bill under 4.1 sub 1 recognizes that the Haida Nation has Aboriginal title within the meaning of Section 35 of the Constitution Act 1982. That recognition is there, of course, under the agreement that's been signed, 2.1, on April 14th, but is not yet binding or effective. But certainly the bill does set out the same recognition, which means that when we look at 4.4 sub 3, that it means something. That the language here is more than what has been done in the past under 4.20 in the agreement as summarized, that there has been, of course, joint decision-making as contemplated under the Reconciliation Protocol and the Reconciliation Act. But with the recognition of Aboriginal title to the Haida Nation, it means something more than that. So in that manner, when we talk about the enactments of British Columbia in relation to Crown land continuing to apply in relation to land, and then in sub 3 we say, the bill says, in clause 2, that enactments of British Columbia that are applied by subsection 2, the one I just referred to, as the minister did, in relation to land that is held by the Haida Nation Aboriginal title, are to be administered consistently with that Aboriginal title and Section 35 of the Constitution Act 1982. So, Mr. Chair, the focus then is on to be administered consistently with that Aboriginal title, meaning the Aboriginal title that is now recognized for the Haida Nation, and Section 35 of the Constitution Act. So, when we think about that language and we look at that language, Mr. Chair, my question through you to the minister is, either before the transition process starts or during the transition process, there's an acknowledgement, certainly in the bill, that enactments of British Columbia that are to be applied in relation to land held by the Haida Nation in Aboriginal title are to be administered consistently with that Aboriginal title in Section 35 of the Constitution. Does that mean then that, for example, when we talk about Land Act enactments, that somehow any decision by the province, the government of British Columbia, to issue, amend, extend tenures under that piece of legislation or any other enactment of British Columbia in relation to Crown land will now be necessary and will now have to get the approval or direction of the Haida Nation because there's a greater recognition. Is that what we mean by administered consistently with that Aboriginal title in Section 35 of the Constitution Act?
Minister.
Thank you. I guess I should start in answering the question by making a very simple point, that the objective is, with the recognition in the first section I referred to, as to treat this as though a court were making the declaration that it made in the Chilcotin-Honeymatine case. That's the effect of it. And so the good news is we've come to an agreement as to what will happen in this up to 2 years transition process. That's set out in the agreement in the Act. But to the member's question, and respecting the Land Act and how that works in the interim, the 4.4 sub 2 of the Act makes clear that enactments in British Columbia, such as the Land Act, in relation to Crown land, such as the Land Act, continue to apply in relation to land held by the Haida Nation in Aboriginal title. And then we go to the clarification, the elaboration found in the specific terms of Clause 4.20 of the agreement. During the transition process, the parties will use the decision-making processes derived from the Protocol Agreement and the Haida-Gwaii Reconciliation Act as amended. That process, initiated under the BC Liberal government, is a cooperative consensus-seeking process in which the Haida have the opportunity to present their consent in decision-making on the land in Haida-Gwaii, a process that has worked extraordinarily well with very little issues where there hasn't been that agreement in the last 12 years, I believe. 14 years since that law was enacted.
Member.
Thank you, Mr. Chair, and I appreciate the Minister pointing us back to 4.20, and he and I agree and understand and acknowledge his references to that, both the Reconciliation Protocol and the Haida-Gwaii Reconciliation Act as enacted by the former BC Liberal government under Gordon Campbell, for which the leader official opposition was a member of cabinet and all of that. We've had that discussion. What I'm talking about, Mr. Chair, is the language in 4.4 sub 3 where it says land that is held by the Haida Nation and Aboriginal title to be administered consistently with that Aboriginal title in Section 35 of the Constitution Act 1982. This is a provision, Mr. Chair, in Clause 2, 4.4 sub 3, which goes on to say for certainty. Otherwise, if the words didn't mean anything, meaning it's all covered in 4.4 sub 2, why don't we just stop there? Why has the government chosen with their drafters to add further clarifying language in sub 3? We have, again, and I understand what the words say in 419 and 420, understand that that's a reflection of where the Haida Nation and the province of British Columbia continue to make progress over the last 14 years. Understand that. But we're talking about this bill, Bill 25, the confirmation in 4.4 sub 2, as the Minister has already said. But I'm looking at 4.4 sub 3, which goes on to say, for certainty, these enactments of British Columbia are to be administered consistently with that Aboriginal title, the Aboriginal title held and recognized by the Haida Nation, and Section 35 of the Constitution Act. So again, through you, Mr. Chair, to the Minister, what is the meaning of that additional language, that additional provision, beyond what's set out in 419 and 420?
Minister.
Thank you very much, Chair, and to the member for his question. I want to start by saying that the member's, of course, right that every statute must be interpreted as as assuming it's a principle of statutory interpretation that the legislature is always speaking for a purpose. So the member, I think, quite properly asks, what does sub 3 add to sub 2? And I think that's important that we try to do our best to elaborate on that. And he uses the example of the Land Act or any other statute in which tenures or permits are granted on what we call Crown land. In Silcoteen, the member will remember that the case led to some uncertainty because as soon as the declaration of Aboriginal title was made, it was essentially unclear what the status of the Crown land permitting process would be. Does the Forest Act still apply? Does the Land Act still apply, given that those lands have been, at least in the declared title area, now subject to Aboriginal title? So the process that has been enacted under sub 2 and sub 3 of this clause is saying in the sub 2 that the laws of British Columbia, like the Land Act, like the Forest Act, continue to apply, notwithstanding that Haida title, as Aboriginal title, has been acknowledged in the earlier part of this bill. But then the sub 3 goes on to confirm that for greater certainty, or the BC enactments in relation to land held by the Haida Nation and Aboriginal title are to be administered consistently with the existence, if you will, of Aboriginal title and that constitutional recognition. So the government decision makers are saying, with respect to Crown land tenures, they must take Aboriginal title into account, but the legislation in relation to land will continue, the laws relating to that will continue. That is the point, that is the clarification that sub 3 adds to sub 2. I hope I haven't confused things by elaborating on in that way.
Member.
Thank you, Mr. Chair. I'm just going to indulge myself in one momentary pause here and then ask the following question of what the Minister has said, because the Minister has put his thumb on just a recollection. I know that the Minister, when he was on the faculty at the UVic Law School, was a colleague of Professor John Kilcoyne, who taught LLP. And as a first-year law student at UVic Law School, which I went to after the Minister left the faculty, I did very well in that course. I had the top mark and have many fond memories of that course, as well as Maureen Fitzgerald. I'm in her book, Legal Research and Writing, as an example of analysis. But in any event, I just want to say this, that when the Minister just said that the enactments are confirmed in sub 2 and how it's administered is dealt with in sub 3, and it's how the decisions will be made, I would ask through you, Mr. Chair, to the Minister, can the Minister elaborate on how decisions will be made and administered in accordance with 4.4 sub 3 in the new recognition, let's say, going forward?
Minister.
Thank you. Before I answer, I just want to say I very much appreciate the member's reference to my former colleague, John Kilcoyne. Professor Kilcoyne was an extraordinary professor of LLP, Law, Legislation, and Policy, and it was lovely to see the skills that were learned by the honourable member being applied so assiduously today. It's very, very good. I'm going to be calling him and giving him an A. Getting to give you a retroactive A grade for statutory interpretation. I changed that, retroactive A plus on statutory interpretation. The question's a good one, and gives me an opportunity maybe to delve in a little bit more about the statutory decision-making process that the BC Liberals brought in under the 2010 Haida Gwaii Reconciliation Act, and how it will be altered, if at all, in the process. I'm going to try to see if I can say this clearly. There are two institutions that have been created in Haida Gwaii since 2010. There's a management council and there's a solutions table at which consensus is sought before a particular decision under the Land Act or Forest Act or any other Land Act statute gets to the normal decision-making process, the kind that applies everywhere else in British Columbia. That process entails an effort to seek consensus. And I'm very pleased to say that that has been the case in virtually every decision over these 14 years, which is really quite extraordinary. But there may be a time, and there has been the odd occurrence, where that consensus has not been achieved. What happens then? And that takes us squarely to Clause 3, as the member pointed out, because it says that for greater certainty, the enactments of BC applied in order to take into account Aboriginal title are to be administered consistently with Aboriginal title in Section 35. And that means that if in that rare circumstance, that a circumstance where consensus has not been achieved, well, there has to be the application of the justification test under Section 35, the Haida test from 2004 in the Supreme Court of Canada. And in that circumstance, the government can only proceed after because it's Aboriginal title that has been recognized after all, if they can demonstrate, if they can meet the very high bar of a justification test. And if they can meet the high bar of a justification test, then the statutory decision makers continue to do what they do. But that needs to be explained through the lens of this whole successful joint decision-making process, consensus-seeking process that has been so successful in Haida Gwaii. So to the specific question that the member asked, back to statutory interpretation, why have they added this? To recognize that circumstance, rare though it is, where one has to resort to the justification test that Section 35 entails.
Member.
Thank you, Mr. Chair. We are touching on the discussion we had yesterday relating to the justification test and talking about the nature of what happens when there is Aboriginal title that's recognized, and the minister just walked us through how in instances where that consent is required, because there is some infringement without agreement, that would need to be stepped through, as we've discussed yesterday in relation to private property. But that, again, the minister said doesn't apply for reasons of the way the bill and the agreement is written. I wanted to just come back to a clarification on sub 2, though. The way that the wording is written, though, is it intended to be interpreted that the enactments of British Columbia in relation to the Crown Land continue to apply in relation to land that is held by the Haida Nation in Aboriginal title? Does that only come into play, though, if we're talking about title lands on Haida Gwaii?
Minister.
Well, thank you. Going back to 4.4 sub 2, I think the answer to the member is a rather simple yes. It only applies to Crown land that is subject to Aboriginal title of the Haida. And that, of course, under the bill, is all of the Crown land on Haida Gwaii, not the fee simple. Of course, we've talked about that.
Member.
Thank you, Mr. Chair. And just to complete my line of inquiry just on this particular provision in Clause 2, I note, and the Minister has made reference in the past to many of the lawyers involved on this arrangement with the Haida, meaning the agreement and the bill. I note there was an article published, written by Denise Ryan back on April 15th. It was last updated on April 16th. Not sure what the publication is in, but it's entitled 5 Things to Know About the BC's Land Title Agreement with the Haida Nation. And it makes reference to Louise Mandel, who certainly is well known in the area of First Nations law, including with the former BC Liberal government under Gordon Campbell. Just 2 questions here. One is, Ms. Mandel, in reference to the actual jurisdictional space, talks about how it will be gradually vacated, the jurisdictional space itself. She says that the land is no longer Crown land, the timber is no longer Crown timber, the wildlife is no longer Crown wildlife, it's Haida land, timber and wildlife. There will be no overnight change in practical terms. Crown lines and collaborative decision-making models already in place will continue through the transition, said Mandel, is what this article says. So obviously we have been through that process, which is recognized in 419 and 420 in terms of the ongoing decision-making processes, the reference by the Minister in terms of the governance structures. The gradual vacating of the jurisdictional space is consistent with the Minister saying in second reading that the province will step back from its responsibility in this area. So as we see the interim measures that are referred to in 4.4 in relation to land, and then we have reference to in 4.4 sub 1 that acknowledging that there will be changes to the laws of the Haida Nation and the laws of British Columbia that are necessary to reconcile systems of government, systems of law, and governance on Haida Gwaii. Just want to ask through you, Mr. Chair, 2 points. One is, what is that interim measure going to look like in terms of that change to the laws of the province of British Columbia that will be necessary to reconcile systems of law and governance on Haida Gwaii? What will that process look like in terms of considerations about vacating the jurisdictional space as Ms. Mandel describes? And could I just get a point of clarification? It says that Ms. Mandel, Louise Mandel, had worked on the agreement with the Haida. Was she working on behalf of the Haida Nation in that capacity, or was she working with the government?
Minister.
Thank you, and I confess I don't know the author, I don't know the publication, I don't know the date. All I can say is that I can be helpful. Ms. Mandel was a longtime lawyer for the Haida Nation. I wouldn't accept all of the characterizations in the rhetorical flourishes that the article contains, nor, for example, reference to the wildlife issue. There's no reference in the agreement or the legislation to the wildlife issue.
See no, member.
Thank you, Mr. Chair, and I appreciate the minister took the opportunity to respond about Louise Mandel acting on behalf of the Haida Nation in this respect, and the quotes. I was more focused, though, as well on the language of the bill itself, which is the reconciling systems of law and governance on Haida Gwaii. That provision under 4.4 sub 1, can the minister provide further explanation as to what he expects will take place in terms of changes to the laws of Haida Nation and the laws of British Columbia in respect of that reconciliation of systems of law and governance on Haida Gwaii?
Minister.
Well, thank you, and we've started from the specifics of the subclauses 2, 3, and now we're moving back to 1, which I think is the general provisions in this section, namely that the member points out that these are interim measures, and changes to the laws of BC and the Haida will perhaps change over time. That's to be expected, I think, but at the moment, the process is very clearly set out in Appendix A, which we've talked about at great length. The agreement contemplates a transition process. It is estimated to take 2 years. It's to enable it says, the reconciliation of Haida Nation and British Columbia jurisdictions and laws consistent with title. Then it goes on to say the initial focus will be on land and resource decision-making, starting with protected areas, fishing lodges, and forestry, et cetera, et cetera. So the interim steps that are contemplated in sub 1 are precisely articulated and elaborated upon in the agreement in Appendix A.
Member.
And just thank you, Mr. Chair. Just one other clarification, just because we had this exchange about Louise Mandel. Can I just get confirmation, though, that Louise Mandel acted on behalf of the Haida Nation in respect of this agreement? Is that correct?
Minister.
Well, thank you. And before I begin, I'd like to acknowledge in the gallery the presence of two other very special guests. I note Chief Tom with Sartlip Nation has joined us. Very much appreciated. And Katisha Paul, who I noted already today in the legislature and is the elected UBC-IC Youth Representative. I'm very pleased to see both of you in attendance with us at this historic debate. To the member's question regarding Louise Mandel. The member, I think, was in the House when on first reading, April 20th, we had a number of people recognized, one of whom was Louise Mandel. She has been a lawyer for many, many years, as the member acknowledged, probably one of our leading experts in Aboriginal law. Her client has been for many, many years the Haida Nation. As I remember, she was counsel in 2004 in the famous Haida case and has been doing this work for many years. But I think the specific answer is Louise Mandel was lawyer for the Haida amongst many other legal counsel.
Member.
Mr. Chair, just to complete the sentence on this agreement, that's my question.
Minister, sorry. Member.
So the minister said yes, and I'll just move on. And back to one other provision before we just follow on with a couple points on Clause 2 to complete it. I wanted to just turn back for a moment to 4.1 sub 2. The minister and I both, I believe, spoke to this provision engaging the honor of the Crown. I certainly did on the second reading, and I wanted to have the opportunity to speak to the minister on the record here. Honor of the Crown typically is something that, as a matter of review and standard and evaluation, is for the courts to determine. How is it that this government is proposing to set that standard in this bill? Under what guise and what standing does the government do that?
Minister.
Thank you, and I appreciate the question from the member. I think it raises an important point. The member is referencing, taking us to clause 4.1 sub 2 for greater certainty. For certainty, the recognition in subsection 1 engages the honor of the Crown. And the member asks, I think quite properly, isn't that for the courts ultimately to determine what the honor of the Crown means? And I think he's right. But the courts are the Supreme Court of Canada just in February the 9th of this year, in a reference from Quebec, a reference re child welfare legislation relating to First Nations, Inuit, and Métis, the court made very clear that it was entirely within the scope of a province or the federal government, one order of government, to make constitutional statements, in this case on reconciliation and issues of paramountcy. But ultimately it said, as I say, that it is for the courts to decide if we got it right. We're prepared to say in legislation for the government of British Columbia that we recognize the solemn nature of this constitutional obligation. The courts have made clear now that it's entirely okay for us to do just that, but of course reserve for themselves the ultimate authority on constitutional matters such as these.
Member.
I certainly recognize the progress that is being made in the province is one way to describe it in terms of since we adopted UNDRIP. I don't know that I can recollect any bill that I've reviewed relating to First Nations, Indigenous peoples in our province that has set this standard in the bill itself. This particular provision sets this for this government and future governments in this province. And I know that I've heard and understood that this effectively, from the government's point of view, will constrain a future government from changing what has been agreed upon under the agreement and under the bill. Through you, Mr. Chair, to the Minister, can I confirm that that is the purpose of this provision?
Minister.
I think the member's question, I think, relates to the nature of this commitment that the legislature is intended to make. I think it's fair to say that our goal in this legislation is to elevate this commitment, the honor of the Crown, to elevate that and to put future legislatures on notice of the solemn obligations that are entailed in this bill. So if a future government were to simply repeal this, then it is our view that that would be inconsistent with the honor of the Crown, unless they had, of course, the consent of the Haida to do so. Having said that, if the Haida and the government of the day were to jointly say that this agreement no longer suits us, no longer meets the needs of the parties, then changes might well occur, and legislative change could occur at that point. But just as the Supreme Court of Canada recently recognized the ability of within its sphere, one government, be it federal or provincial, to take on things of solemn constitutional import, we're doing the same in this bill, in the hopes that the message is received by future legislatures. We think this is a solemn undertaking. It comes out of an agreement after many years of litigation, and that is what we're intending to capture. I reiterate what I said in my last answer, that it is always for the courts to determine whether the honor of the Crown is engaged.
Member.
Thank you, Mr. Chair. And this government has decided to take this step to include this clause that I have not seen in other pieces of legislation in the last 7 years that I've been a member here, and certainly the last 4.5 to 5 years since I've been very focused on the implementation of UNDRIP and Declaration of Rights of Indigenous Peoples Act. So recognizing, Madam Chair, that this is the higher standard, so to speak, that this government has chosen to impose on this particular piece of legislation, it has underlined the point. That's the reason why we've wanted to take the time and also call for this to be an exposure bill, to pause the proceedings in terms of the nature of this new template, this new model. Here we are. We're in the 5th day of this committee process on this bill. And it's with this in mind that even when you look, Madam Chair, at Clause 4.1 sub 2 of Bill 25, it does, as the Minister has explained in the way that he's able to set that higher expectation on government, on future governments of this province of British Columbia. And we, of course, recognize and respect the long-standing relationship with the Haida Nation. And yet, this should be the case with any First Nation that the government of British Columbia is having a relationship with. And yet, it has chosen to specifically specify this in particular with respect to this one nation. It's the reason why, as this bill continues to move forward through the committee process, it's important that we have what myself and the Leader of Official Opposition has been calling for, which is clarity and certainty. And it's with that in mind, and to follow on the discussion we had yesterday in committee in particular, when the Minister confirmed that Section 1 of the Act itself, the Haida Nation Recognition Act, does not give any additional governance authority over fee simple lands, that the reason for that is spelled out in the agreements, such as, for example, Clause 4.12 and 4.13, and other provisions. That it's with that in mind, Madam Chair, that I at this time would like to propose an amendment to Clause 2, and I can just hand that up to yourself here and the clerk.
If you can read it and make your comment.
After I hand it up, I'll do that. Thank you. So I move in Committee of the Whole on Bill 25, entitled Haida Nation Recognition Amendment Act, to amend as follows: in Clause 2, by adding the underlying text as shown under Section 4.3, it states in fee simple, which is titled that way, for certainty, nothing in Section 1 of the Act provides the Haida Nation with governance authority in respect of any lands for which immediately prior to entry into force of Section 4.1, a party other than the Haida Nation held indefeasible title under the Land Title Act, RSB C 1996, Chapter 250.
If you'd like to make some comments, member?
Thank you, Madam Chair. As I was saying prior to moving that motion, I am raising this proposed amendment to Bill 25 in order to provide for the clarity that the minister has explained at the committee stage. The minister has pointed to, for example, provisions in 4.12 and 4.13 in respect of local governments, that they will continue to exercise jurisdiction under provincial laws. We had a discussion relating to how local government boundaries through the transition process will identify options and approaches to be reviewed on those boundaries consistent with the recognition of Haida Aboriginal title, for example, and that the minister has continued to confirm that in the committee process that the recognition under the Haida Nation Recognition Act under Section 1, that the Government of British Columbia recognizes that the Haida Nation has inherent rights of governance and self-determination that is specific to the nation, and that is not intended in any way to provide additional new governance rights of the Haida Nation over fee simple lands. My proposed amendment that I've tabled here speaks to that and puts that directly in the bill so that's clear language for certainty that nothing in Section 1, the section I referred to, that's under the Haida Nation Recognition Act, would provide Haida Nation with governance authority with respect to those fee simple lands. So certainly in the absence of excluding the fee simple lands separately from Haida title, which we've discussed, this particular amendment to this bill at least makes it clear that there's no additional governance right for the Haida Nation, as the minister has confirmed repeatedly during the committee stage by reference to various sections of the agreement, including 412 and 413. So this motion is made in order to clarify the language of Bill 25 so that for all those that are looking at the bill, for all those who may in the future want to use this as a model, for all those who might want to use it as a template for other recognition of title arrangements, that we have clear language, at least at this juncture, recognizing the higher standard that this government is imposing on this bill, on the government in the future, that it engages the honor of the Crown. This is an amendment that it seeks to ensure that we have clarity from the beginning of the bill. And so that's the reason why I've moved this amendment.
We'll take a brief recess while we examine this amendment. Call the committee back to order. The chair finds the amendment in order. Any further comments that members would wish to make? Recognizing the minister.
And I start by saying that after consideration, I will be voting against the proposed amendment. I do so for perhaps three different reasons. The first is that the amendment is inconsistent with the basic model of recognition that is designed in the agreement and recognized in the Act. It's a recognition of the title of the Haida Nation. And they, in that agreement, have confirmed that that fee simple privately held land is not engaged in our enterprise together. I do so secondly because the member has tacked on or proposes to tack on for 4.3 dealing with land issues, something that relates to Section 1 of the Act, which deals with governance. I spent considerable time yesterday delineating what I thought was a clear difference between the governance of the Haida Nation, which we've recognized, and the member voted for in the past, and the jurisdiction over lands in light of Aboriginal title, which is the subject of the bill before us today. So it is, in my view, the member is, through this amendment, proposed amendment, conflating jurisdiction and governance in a way I thought we clarified or I attempted to address yesterday. And the third reason I would reject the amendment, and I will vote against the amendment, is it's superfluous. We've spent days, we spent 5 days, I think, on this, and I thought we've had many exchanges about the degree to which fee simple is protected in this bill, and I therefore see no reason to A, conflate it with something in Section 1, 2, to be inconsistent with the recognition model, or 3, to do something which would be superfluous to our exercise.
Recognizing the member from Vancouver-Langara.
Thank you, Madam Chair. I just want to respond to the minister's 3 points, and it does give me the opportunity to reflect on the discussion we had yesterday. Just on the third point, in terms of this being superfluous, we had a discussion yesterday at committee, and this is the 5th day, Madam Chair. We had a discussion when the minister was pointing back to, again, as I mentioned in my introductory comments in moving this amendment, to Section 4.12, for example, of the agreement. And the comment I made back, Madam Chair, was that, well, that's in the agreement, and that's between the Haida Nation and the government of British Columbia, but it's not in the bill itself, and that's what I said at the outset. And really, those fee simple landowners are not party to the agreement. I don't believe, of course, that this amendment is superfluous in the way that the minister had indicated. It is for certainty, and the bill, this follows the drafting style in the bill, which does make reference to other for certainty type language, including the one that we just reviewed in 4.4 sub 3. As the minister will well know, there are times where in legislative drafting there needs to be for greater certainty or for certainty type provisions. This is the reason why I'm proposing this additional wording, to make it very clear for reasons that I spoke to earlier. The other 2 points, clearly on both points, the minister and I have a disagreement. And that can happen, of course, that we don't agree with each other in terms of how this bill is framed. I have said that a year ago, when we had the discussion about the Haida Nation Recognition Act, there was a provision, Section 1, which is the provision that I'm speaking to here in this amendment. But there is an interplay between governance, recognizing the inherent rights of governance and self-determination for the Haida Nation, and recognizing the underlying title to all of Haida Gwaii under Section 4 of the Act, which is what this bill will do by amending the Act in order to incorporate new provisions dealing with Aboriginal title under Part 2 lands. My concern is that we're now bringing into effect, under the Recognition Act, both what we've had before, which is inherent rights of governance and self-determination, alongside of now title recognition. Well, clearly, for those landowners, those who hold fee simple interests on Haida Gwaii, for whom the consent is clearly spelled out in the agreement, as the minister has said repeatedly, and in the bill, that there needs to be some understanding as to the nature of the interaction between these two sections. That's what I am saying, and that's the reason why the amendment is sitting in 4.3 under estates and fee simple lands, recognizing, of course, that Clause 1 of the bill, or Section 1 of the bill, is not what Bill 25 speaks to, not really, other than renaming the title, in effect, that this is the provision to add clarity. And again, Madam Chair, we do have a disagreement over the jurisdiction, the lines drawn. I do not actually see, when we're saying the Haida Nation has rights of self-governance and self-determination, that means they have rights of governance and self-determination over all of Haida Gwaii, because now we're recognizing their title. That's the reason why there's a 2-year transition period for the jurisdictional space to be relinquished, for this government to step back from its jurisdiction over Crown lands, for example. This is the reason why we are dealing with this. Now, having said that, the minister has said repeatedly that fee simple lands are not affected. They're not affected in the transition process. So these words are there for greater certainty, and that's the reason why I would encourage the committee, all members, to consider this amendment and vote in favor of the amendment.
Minister?
Well, thank you very much, Madam Chair, and I thank the member for the thoughtful amendment, and I hope I was respectful in my response. I continue to believe and will vote against the amendment for the 3 reasons I articulated. I had the benefit to take legal advice, and I have concluded on the basis of that advice that 4.3 provides the clarity the member seems to think is lacking. He would want to tack on another section for greater certainty. We don't think it's necessary. The plain reading 4.3 is a state in fee simple in relation to land on Haida Gwaii, whether before or after this section comes into force, is confirmed and continued. I don't know how much clearer we can be. I simply do not believe that that additional clause that the member proposes would achieve its objective. It would be superfluous. And with that, I will vote against the amendment.
Seeing no further members, I'll call the question on the amendment to Clause 2 of the Bill 25. Those in favor, please say aye.
Aye.
Opposed?
Division?
Division has been called. Before putting the question, I remind all members that only the members of Section A or their duly appointed substitutes are authorized to vote. The question is on the amendment to Clause 2 of Bill 25. Those in favor, please rise or otherwise indicate. Thank you. You may be seated. Those opposed, please rise or otherwise indicate. Thank you. You may be seated. Clerk?
Mr. Letnick,
I vote yea.
Mr. Walker,
I vote nay.
Clerk? Oops, sorry.
Lee Letnick Morris, 3. Those voting nay, Rankin, Deeth, Cullen, Babchuck, Bailey, Malcolmson, Routley, Parmar, Olson, Walker, 10.
On to back to Clause 2, recognizing the member from Vancouver, Langara.
Thank you, Madam Chair. Yesterday at committee level, we also had a discussion in relation to, does the minister need?
I was just going
Yeah.
to suggest we wait just a second so
Okay.
that staff can return to their seats. My apologies. All right, let's start again. Member?
Thank you, Madam Chair. Yesterday at committee level, I asked a series of questions in relationship to formal consultation with financial institutions relating to the new recognition of title here under Bill 25 and Clause 2. The minister indicated that the Council of the Haida Nation had received 2 letters, one from the Bank of Montreal and the other from a credit union in the north. I'd asked whether it'd be possible for those letters to be shared. I just wanted to ask the minister, first of all, is that possible? Are we able to obtain and share the copies of the letters that the Council of Haida Nation received in connection with Bill 25?
Minister?
Thank you. Yesterday, just for clarification, I said that there were 2 financial institutions, and I named them. I indicated there was one letter of which I was aware, letter sent to the Council of the Haida Nation. I undertook to ask them if they would be content with that disclosure, and I will do so. I have yet, because of the timing of this committee, the member will understand, had an opportunity to do that, but I reiterate that I will.
Member?
Well, I appreciate that, Madam Chair, and I appreciate the minister's efforts with his team. We've talked about before about briefings, not just with this bill, but all the bills that the minister has been responsible for in this chamber. The level of cooperation and has been certainly enabled me to do the role that I play in all of this. Having said all that, we had a discussion, Madam Chair, about this, and meaning the potential impact, which is unknown at this time. We understand, as the minister has clarified, and I do remember, as the minister clarified this yesterday, that there is one letter received by the Council of Haida Nation from the Bank of Montreal, one of the major financial institutions of our country, of course. But the government itself, and we had this back and forth, Madam Chair, about engagement versus consultation, and we don't need to repeat that here. But really, my understanding is that in view of the fact that the government has not conducted a formal, comprehensive level of consultation with details to turn the minds of financial institutions of our province or our country to the nature of the new form of recognition of Aboriginal title, in this case to the Haida Nation, on Haida Gwaii, that there is some area of unknown outcome, let's say. that when financial institutions look at this new arrangement and recognition of title, and a fee simple owner goes to renew their mortgage or goes to sell their property to a new willing buyer, willing seller arrangement as contemplated in the agreement, that is not itself the Haida Nation, and that purchaser needs to get a new mortgage on that property that's being acquired, that there could be a potential, a possibility, let's say, a possibility that there could be some other view that the financial institution would take relating to the certainty around title underlying the mortgage instrument that would be provided. So in that regard, I have another amendment to propose to this bill in order to clarify and to provide that level of protection in the event that that possibility might occur. So I will just hand those amendments up, and I'm happy to speak to the nature of this amendment to Clause 2, Section 4.3, Sub 1.
Member, you may read the motion.
I move in the Committee of the Whole on Bill 25, entitled Haida Nation Recognition Amendment Act, to amend as follows in Clause 2 by adding the following clause, 4.3, Sub 1. If, as a result of anything in this Act or the Rising Tide Haida Title Lands Agreement, Sub A, a person holding indivisible title to land under the Land Title Act suffers a loss in the value of their property or is unable to sell their property, or Sub B, a person holding a charge under the Land Title Act as security in respect of lands on Haida Gwaii is unable to realize on such security, the person may bring an action to recover damages against the government under this section.
Would you like to speak to the amendment?
Thank you, Madam Chair. I have, in my introductory comments already, reminded the committee of the exchanges that we've had, the Minister and I, about this point. It is my view, in reviewing the responses and hearing the responses in the first place, and then reviewing the responses of the Minister, that this is an uncertain, unknown area of the bill, that it has not been fully, comprehensively assessed with financial institutions, that there is some unknown possible outcome to both persons holding title to land, for which their value of their property may be have some detrimental impact, or secondly, a person holding a charge, which should be a financial institution or other lending institution, may have difficulty realizing on their security. So this is in reference to the new model, or the new template of recognition of Aboriginal title to the Haida Nation with the consent under the agreement and the bill itself under Bill 25. That this is a new approach which has not been fully tested, not that I've heard from the Minister, with the financial institutions that are involved in lending to property holders, including on Haida Gwaii. So this is the reason why I'm bringing forward this amendment, which I did speak to in concept with the Minister about yesterday, meaning the concern around the possibility unknown, that is, that a lender may take a different view relating to the security that it has on a particular piece of property on Haida Gwaii, fee simple lands that is, or that fee simple holder may also have some detrimental outcome due to the nature of the Act, the bill itself, or the agreement that has been put in place between Haida Nation and the Government of British Columbia. So this is the reason why I bring forward this amendment, in order to ensure that those fee simple landowners and those who lend to fee simple landowners on Haida Gwaii have the level of protection for the value to which they had prior to the entry of the amendment and Bill 25.
Thank you, member. We will take a brief recess while we examine this amendment. committee back to order. And the amendment motion is in order. And if there was anybody else that would like to speak, recognizing the House Leader of the third party.
Thank you, Madam Chair. And I think I'll speak directly to the amendment. I have been watching as this debate goes and have had little opportunity to intervene. I do want to just, I think, make a comment briefly on the fact that the member, the critic here, has repeated often about the request that he and his leader have made to delay this bill and for exposure, or however they're framing it. And we've heard the member, and I think that it's important to put this in context. Yesterday, another member of that caucus stood up in question period and said this: "We use the word reconciliation a lot in this place, and for good reason. Isn't it time that the government tried to reconcile with the law-abiding and, yes, by definition, God-fearing folks who drew on their faith during a very difficult time and couldn't understand why they could go to a Pilates class but couldn't go to a church? Those proceedings have been going on for 3 years. Over 3 years." He repeated, over 3 years. And the government, I can assure you, Mr. Speaker, has spent a fortune on multiple applications, sometimes appearing in court with 5 years. Well, I've just had it confirmed, that this action that we are talking about here, and hopefully at some point we'll be able to celebrate, has been going on for 25 years, member. At great expense to not only this provincial government, but also to the Haida people for 25 years. So I think that it's important to put this in context. Well, this member sits down here and calls for us to put pause to something that has been going on for 25 years. Members of his own caucus are standing up with a great deal of frustration that something could be going on for 3 years. I think this just provides a little context to the kind of the kind of approach that's being taken with this bill. And I think that it's important that it be said. It was very difficult for me to keep my composure while I heard that yesterday, and I needed to put the context in here. I think it's very difficult for me to support this for a variety of different reasons, but simply, if you take a look at the last sentence here, it says recover damages against the government under this section. And I think just at this very, the members looking for clarity, and the own amendment here that has been tabled provides no clarity. Which government? This government? That government? The federal government? The government of the Haida Nation? The Council of the Haida Nation? The local government? Which government is the member? So in an effort to try to seek some clarity here, there is a lack of clarity in this amendment, and for that reason I won't be supporting it.
Member,
Just to respond,
Vancouver Langara.
Just to respond to the leader of the House Leader of the third party, if the member chooses, I'm happy to propose an amendment to clarify the language. Clearly, the language of the bill says the government of British Columbia. To be clear, that's the intention of the amendment, that it is the government of British Columbia under this section that for whom an action may be brought. Madam Chair.
So, member, you are requesting the addition of?
What I'm hearing is the leader of the House Leader asking for clarification on my amendment. And he's quite right. The intention is to make it clear that it is, as is in the Bill 25, it is the government of British Columbia in all cases. So this language should be, I agree, stating that it's the government of British Columbia. So I would choose to just amend my own amendment, and if the member wants to do that, happy to amend this amendment proposed to just say the government of British Columbia.
If we can seek unanimous consent of the committee to the amendment to change the wording from against the government to against the government of BC. Those in favor?
Aye.
Opposed? Okay, it's Appears to be in order then, and recognizing the minister.
Well, thank you very much, Madam Chair, and I want to start by recognizing the presence in the gallery of Jessica Wood, who, of course, is the heads up the Declaration Act Secretariat, Deputy Minister in that institution. So pleased that she could join us. Before going to the specifics of the amendment proposed by the member for Vancouver-Langara, he has said a couple of times now that I referenced a letter from the Bank of Montreal. I advised that there was a letter from the credit union and that the Council of the Haida Nation had engaged with the Bank of Montreal. So for the record, I wanted to make sure that's clear. Now, against the amendment, I wish to indicate, Madam Chair, that I will be voting against the proposed amendment. This is, of course, another reference to fee simple land, and this time contemplates damages against the provincial government for losses that are due to inability to sell or mortgage the property. That's essentially what the member's saying. So it's a variation on the theme, if you will, that we've already, for which an amendment has been proposed and which we have rejected. So the first point I'd make is that the premise of the member's question I reject entirely. He asserts that they, quote, uncertainties over fee simple land. For reasons that we've spent 5 days now, I reject that that uncertainty exists. Fee simple owners have not lost any private property rights, will not lose any private property rights as a consequence of this bill. We don't agree that they have lost any property rights, and therefore damages being a claim for that loss are not in order. Secondly, the member has no evidence that he has presented, no evidence for his assertion that there is a problem that private property owners would incur selling or mortgaging their land. He's made that assertion, but with no evidence. I think he referenced a chat with some bankers or something. That's all the evidence he's provided. Thirdly, I want to use his expression. He states concerns of possibilities unknown. Those are his words. In other words, emphasizing the entirely speculative nature of what he's proposing. He also says that, and I need this to know, the member's amendment would itself create uncertainty, casting doubt on fee simple and the nature of that protection that we've provided elsewhere in the bill. By putting forward this, anticipating there could be problems on selling land or mortgaging land, the effect of the amendment would be to create the very uncertainty we're trying to avoid and have taken so many pains to avoid. I reiterate that the bill before us very clearly says in 4.3 that fee simple, an estate in fee simple in relation to land on Haida Gwaii, whether arising before or after this section comes into force, is confirmed and continued. How is that uncertain? And finally, Madam Chair, there's nothing in the laws of British Columbia that prevents an aggrieved person from seeking a remedy under other legislation against the Crown. That can always be done under the Crown Proceeding Act, under the Judicial Review Proceeding Act, under many statutory remedies, as the member knows. So therefore, this would add nothing and take away the clarity that we have tried to provide elsewhere in the bill.
Member, Vancouver-Langara.
Thank you, Madam Chair. I will just note a number of things before responding. The Judicial Review Procedure Act is a bill that the government brought forward, Bill 39, back in 2022. And this is a bill that we had 1 minute and 45 seconds to review because there was a time allocation order. This is when, it's on the record, I'm reading from Hansard here. The committee met at 1:24 and time allocation being what it was, they shut down committee on that bill. And myself, having come in from another bill, Bill 38, which was not brought forward with time allocation, and that was the Indigenous Self-Government Bill in terms of taking back responsibility for care for children, a very important bill. Just like Bill 25, as I noted earlier, the government has not brought time allocation to this bill, and I'm appreciative of that. But when the minister mentions the Judicial Review Procedure Act and how that can be utilized, I don't know. Because this government brought forward closure on that bill. This is in response to how that bill would be dealt with in respect of Section 7 of DRIPA. So I know that the member, the House Leader for the third party, he's a strong voice in this chamber. And I respect what he said in terms of his reaction to my colleague in question period utilizing the term reconciliation in a different context. But I also know, of course, that in the 4.5 years, the 5 years coming on, in terms of the implementation of DRIPA, for which that member that the House Leader of the third party speaks about, joined me in that review of UNDRIP over 5 committee days. And so we are in the opposition. This is the role that we play. This is the reason why we don't have the opportunities to have the full review of what the minister had announced back in March, when the Leader of Official Opposition and myself, the House Leader is quite correct, we called for a pause on this process. This was back on March 22nd. This is before the agreement was entered into. We have spent some time, and we've talked a lot about the 25 years. We talked about that with the Haida Nation Recognition Act a year ago, in the time that we had. We've talked about it here, both on first reading and second reading. We understand the context, the time. We do. But this is just an example, Madam Chair, of the kind of issue that does need to be addressed. Now, members of government and this minister may not agree, but this is the role we play. This is the reason we asked for a pause in the process before the agreement was entered into, based on what the minister had put out in his first press release. When the bill was introduced on April 22nd, we again put another statement out calling for this bill to be made an exposure bill. What does that mean? For this bill to be given more time and opportunity and space to have that broader level of consultation, including with financial institutions, for example. And so the opportunity for that broader consultation has not been done by this government. This is what the minister confirmed yesterday and today. This is the reason why I'm bringing forward this amendment to Bill 25, to ensure there's clarity and certainty for those landowners and those lending institutions that this new form of recognition of Aboriginal title, by virtue of the agreement and this bill, will ensure that their interests are protected as well. I get the fact that this is an agreement with the Haida Nation. I get the fact that this is years in the making. But when we are challenged again about the role that we're playing, I think I have to be very clear about why we're doing what we're doing and the reason for making this amendment. And so, as I said before, I have, we all have our roles in this chamber, and I appreciate that members on the government side, the members of the third party, and certainly the respective members in our gallery have the opportunity to make their contributions to this debate. But I also have the opportunity to respond to what has been a continued criticism of the role that we play. We asked for a pause in the agreement because we know that we need to have more time and space so that British Columbians can understand this. This has been a very clear position for the Leader of Official Opposition, the BC United Opposition, and myself, that we have to bring everyone along when we talk about reconciliation. That it is not just enough to do what this government continues to do, to bring forward fundamental changes without that broader consultation. So in this case, this government having had the opportunity, knowing the timing of this, because they're in control of the timing, Madam Chair, introducing this bill in the dying days of this legislative session, and watching the minutes and counting the hours of debate, and putting that constantly in our face. All we're doing is trying to ensure there's clarity and certainty for British Columbians about this new template, this new model of recognition of title in our province. If the member across the way had been listening to my speeches on first reading and second reading at the committee level, that member would not keep repeating that comment. I certainly will have respect for that member when he gives his farewell speech. The point is, we all have our time in this chamber. I have been challenged once again. I'm going to respond to that challenge. But it does demonstrate the point, Madam Chair, which is that the reason for this amendment is because there is uncertainty. There is a question, because the government has not assessed that concern. It has not directly engaged with financial institutions to ensure there isn't any impairment of value, both to those landowners and to the lenders who hold security on those lands, for the manner in which this title is being recognized. That's the reason why we brought forward this amendment, and it ensures that there is some level of protection in the absence of that formal, comprehensive consultation that ought to have occurred, which is the reason why, again, we called for the pause and for this to be an exposure bill. Because clearly the government has not fully done its responsibility and its job to fully assess the impact of this bill and the agreement. That's the reason why we brought forward this amendment, to at least at this juncture give some level of protection. We are not certainly in the same place as the government's been in, or the Haida Nation. The Council of Haida Nation has, for reasons that are not entirely clear, because we haven't seen the one letter that came back. I don't know exactly what was the purpose of the letter. Why was the letter provided by the financial institution? Perhaps it gives the level of comfort that I'm looking for both lenders, other lenders who may take a different view, right? We're talking about BMO and a credit union in the north, right? They are not necessarily speaking on behalf of all lending institutions regulated by the federal government, who are not a party to this agreement. So, this is the certainty that we seek. This is the reason why I would encourage members of this committee to consider the amendment, to provide the kind of protection, recognizing that this is, again, the template legislation that is raised to the level of standard of honor of the crown. So, far be it for a future government of the province of British Columbia to alter this legislation, not just in respect to the Haida Nation, but this is the template, this is the model that the Premier has put forward. It doesn't have the level of protection that is put forward and spelled out in the amendment that I just made. That's the reason why I encourage members of this committee to vote in favor of this amendment.
Minister.
Well, thank you. I just need to say for the record, Madam Chair, that I never challenged the member for the role he is playing. I've acknowledged his good faith contributions to this debate. I just don't understand, however, I come from a different place in federal process, and I stand corrected. On clause by clause, one doesn't go back and talk about the process leading up to the bill or proposing a different process. My understanding in these 5 days and 17 plus hours is that we are here to talk clause by clause about the specifics of the bill. The member continues to talk about a process suggestion that he made for an exposure bill. And then will now say we haven't given him enough time, I suppose. I guess that's the corollary to that. But I simply need to say that when I referenced the Judicial Review Procedure Act, I didn't know it was such a trigger. The bill was passed, in my knowledge, 1974, copied from the Ontario Judicial Review Procedure Act. It provides a route, as the member well knows, to take action to seek judicial review of government decisions. I also said that there are many statutes that have appeals, as the member well knows. I also said that there's a Crown Proceeding Act, which contemplates and provides a route for seeking damages against the government. All of which is to say, I don't know what it adds to put a section here that will only cause additional confusion and uncertainty. The member's continuing assertions about that uncertainty I've rejected categorically. He asserts and therefore assumes that that's the case. There is no such uncertainty. How many times must I read the section of the Act and the agreement that make absolutely clear that private property is protected? So I just find that the speculative nature of what the member is proposing is, and the fact that his remedies are available, that remedies for aggrieved people are available in other statutes of the province and at common law, for concerns of possibilities unknown, to use the phrase that the member uses, demonstrating the speculative nature of what he's suggesting, does not argue for the need for an amendment of this sort. And for reasons I've suggested, this would only muddy the waters and add to uncertainty, which we reject exists. And for that reason, I will be voting against the amendment.
Seeing no further speakers, those in favor of the amendment to Clause 2 of Bill 25, and just to let you know in advance of the vote that the member has agreed to amend the number to be 4.3.1 rather than using parentheses, and the committee has unanimously agreed to adding the words of British Columbia to the final phrasing, which says damages against the government of British Columbia under this section. Those in favor of the amendment, please say aye.
Aye.
Those opposed?
Nay. Division.
Division has been called. Members, if we can have unanimous consent, we can hold the vote at this time. All those in favor? Aye. Opposed? Okay, looks like we've got unanimous consent. My favorite moment. So before putting the question, I remind all members that only the members of Section A or their duly appointed substitutes are authorized to vote. The question is on the amendment to Clause 2 of Bill 25. Those in favor, please rise or otherwise indicate. Thank you. You may be seated. Those opposed, please rise or otherwise indicate. Thank you. You may be seated. Clerk. Oops, I did it again.
MLA Walker,
I vote nay.
Clerk.
those voting aye, Ashton Morris Lee, 3. Those voting nay, Rankin, Babchuck, Deeth, Bailey, Malcolmson, Routley, Parmar, Cullen, Olson, Walker, 10.
Motion is defeated. We'll just take a moment to bring back the staff. And we're back to the main bill and on Clause 2, recognizing a member from Vancouver-Langara.
Thank you, Madam Chair, and I appreciate the minister's response. And I know that he knows that in the 2 years that we've been across from each other in the roles that we play, that I've always found we obviously have our points of difference, but the discussion has been mostly constructive, and I was not taking any specific issue with the minister himself. Obviously, he represents a government, of course, that I have issue with, and he communicates on behalf of that government, and that's what he is doing in different ways. So that's, if there was any response that the minister was picking up that he felt he needed to respond to, that's what that was. But in any event, I just wanted to give the minister an opportunity to clarify in the midst of that exchange that we were having about the amendment that has now failed. I just wanted to clarify a point because, again, yesterday we had the discussion about it would seem that the minister has referred to this letter from the Bank of Montreal, that the letter is supporting the approach that is being taken between the Haida Nation, the Council of Haida Nation and the province of British Columbia. And so I just wanted to have the minister clarify because just thinking about and recollecting what he said in this context today, I just wanted to make sure that he's clear on what's his understanding of the letter that has been received. Is it from the Bank of Montreal or the other Northern Credit Union? And secondly, what is his understanding as to what the letter actually does say to the Council of Haida Nation in respect of the agreement and the underpinnings of Bill 25?
Minister.
Thank you very much, Madam Chair. I reiterate what I've now said twice. There is no letter to which I've referenced from the Bank of Montreal. I referenced a letter from the Northern Savings Credit Union sent to the Council of the Haida Nations. I said that the leadership had conferred with the Bank of Montreal. The member asks what the letter contains, and I've undertaken to provide that letter to him. But I can tell from consultation with our engagement with my staff that the letter will say that, or did say, that the credit union in that case was supportive of continuing to lend on Haida Gwaii and congratulated the Council of the Haida Nation for this achievement.
I'd just like to ask the member to ensure that the questions are relevant to Clause 2 and make sure that you can clearly articulate that relevance.
Thank you, Madam Chair. That was a follow-on, of course, of the discussion we've been having about Clause 2, and obviously the amendment that we just went through was related to the lack of clear understanding as to what the current standing is relating to this new recognition of title for the Haida Nation in respect to financial institutions. So that question was a follow-on, just to ask for clarity around what has been communicated to the Council of Haida Nation. I just to conclude on Clause 2, we had earlier reference to Louise Mandel and the role that she's played on the agreement for the Council of the Haida Nation. We've heard that she's been engaged, as is consistent with the representation over many years, as the minister has referred to Ms. Mandel for the Haida Nation and other nations in this province. I just wanted to ask for you, Madam Chair, to the minister, just to clarify the role, though. Does Louise Mandel have any current engagements with the government of British Columbia? I note that her law firm has received funds and trusts in respect of a disagreement, but I presume that that is in respect of her client's interests as opposed to any direct engagement with the province of British Columbia. I wanted to just clarify that one point.
Minister.
I take your advice on whether that's relevant to the clause-by-clause analysis before us, but I will answer the question to the best of my ability. I've already answered on a couple of occasions that Louise Mandel has been the longtime lawyer for the Council of the Haida Nation. He asks another question about contracts or something with the province of British Columbia. I can tell the member I have no knowledge of that at all.
Shall Clause 2 pass? Aye. So ordered. Shall Clause 3 pass? On Clause 3, member.
Thank you, Madam Chair. On Clause 3, this is the area of the bill that the Minister and I have had some lengthy exchanges and discussions about. This does relate to an amendment that I would like to propose at this time. Yesterday, near the end of committee, and this morning, we had exchanges about whether from a drafting approach, as the Minister suggested, or wasn't, as the Minister referred to, what I was postulating when I asked the question as to wouldn't it just be simpler, given the level of confirmation that is provided in the agreement and the bill itself in terms of the Haida Nation recognizing that fee simple interests are continued and confirmed and consented to, and all of the other protections relating to fee simple interests that we discussed, wouldn't it just be simpler to exclude that from the definition as set out in the schedule to the bill? And so my proposed amendment, if I can read it into the record, is as follows. I move in Committee of the Whole on Bill 25, entitled Haida Nation Recognition Amendment Act, to amend as follows in Clause 3 by adding the underlying text as shown, and that underlying text, underlined text, would continue on, comma, after the words Haida Title Lands Agreement, excepting those parcels for which, comma, immediately prior to entry into force of this act, a party other than the Haida Nation held indefeasible title under the Land Title Act, RSPC 1996, Chapter 250. So if I can speak to that amendment, Madam Chair.
Yes, please.
this amendment puts in front of this committee what I was asking about yesterday and into as to whether this alternative drafting approach would just make things simpler. It certainly would make things clearer and more certainty that we would, apart from all the other confirmations that have been set out in the agreement and the bill itself, this would be an additional level of clarity on the schedule. So again, with the two other amendments that we proposed being voted down by the government members and others, we are the only members that voted in favor, which are the BC United members here in the committee. I am proposing this amendment to add, in the absence of those other amendments, this would clarify at least, at a minimum, that there is no question about fee simple interest being protected in the way that it is excluded from the actual, what's referred to as the Haida lands, as set out in and referred to, Madam Chair, under Section 4.1 Sub 1 of the bill itself. We've just passed, the government has passed Clause 2, which does say that the government recognizes that the Haida Nation has Aboriginal title within the meaning of Section 35 of the Constitution, Act 1982, to land on Haida Gwaii as described in the schedule to this act. And so the reference to the schedule, Madam Chair, is set out in Clause 3. I am proposing an amendment to Clause 3, which describes the schedule to exclude fee simple lands, those lands that are registered with the Land Title Office immediately prior to the coming into force of this act. That would mean, as the Minister and I have been discussing, whether the civil pleadings in the litigation needs to be amended or not, that is something that the lawyers, of course, to the parties will have to determine. I think that there is already contemplation of the need to amend certain pleadings in the respect of the federal government still being in the litigation proceedings, but that still, as I understand it, it may not need an amendment to the pleadings. I've said that obviously the opposition, the BC United opposition, have not been at the table while the agreement's been negotiated. So, and I appreciate that we had some degree of recognition, certainly in the discussion, that the Haida Nation has their reasons as to why in the negotiations and obviously in their claim, they've claimed all of the title interests, and they are, with this mechanism, though, consenting to fee simple interest continuing in a way that the Minister has said fee simple interests are protected in perpetuity. All I'm saying in this amendment is that makes it very explicit and clear that not only is it protected, but it's excluded from the actual definition as set out in Schedule 2 this bill as to what the Aboriginal title is that the Haida Nation have. That we're excluding what has been referred to as approximately 2% of the land base, those that is underneath the fee simple interests of those who are not, for which the Haida Nation is already consenting to, would be fully protected and not part of the transition process by government. In this morning's discussion, we talked about, the Minister referred to this whole point about, well, if we exclude it, then it's going to be back into litigation. I disagree with that point, and I've said the reason for that is because we still have the bill itself that has not been amended to date. We still have the agreement that's been entered into between the parties. And there is recognition that even in 4.3 of the bill, which has passed, Clause 2, that the estate and fee simple and the interests and rights or rights in relation to the land that derives from burdens or otherwise relates to an estate and fee simple are confirmed and continued. This is what the bill clearly spells out. This is one of the areas, Madam Chair, where that recognition of the confirmation and continuance of fee simple interests are set out in the bill itself. So with that in mind, this amendment would merely add to the clarification and certainty in the bill And that's the reason why I would encourage the minister and the members of this committee to consider this amendment to the bill itself.
We will take a brief recess to review the amendment. Call the committee back to order, and the amendment is in order. Recognizing the minister.
Thank you very, very much, Madam Chair. First of all, I will indicate from the outset that I will be voting against the amendment for reasons very similar to those presented with respect to the other two amendments, but with a couple of additional reasons. I want to begin by thanking the member for acknowledging that we have had, as he puts it, lengthy exchanges on this already, and for acknowledging as well that he and his party were not at the negotiating table. Those are two things he said, and I appreciate that recognition. He also acknowledged that the Haida Nation, quote, have their reasons or may have their reasons. I reiterate that the clause which has now been that has been before us in the bill for many exchanges now, confirms and continues the estates in fee simple. Now, the member says we need greater clarity. He's been saying that, and I believe that the clarity, for reasons I'll come to in a moment, has been provided. He talks about the 2.2% of Haida Gwaii, which is in fee simple. Half of that 2%, as I've indicated, is held by Mosaic Forest Products. Myself and my team have had several meetings with them, and not once did those primary fee simple owners, the largest fee simple owners on Haida Gwaii, express any word of concern. The member now talks about amending the schedule, putting in exclusions of parcels that are held in fee simple from the map that would be scheduled in the bill. I just would reiterate that this would therefore create an inconsistency between the signed agreement and the bill, causing unnecessary confusion. And it would also, the member alluded to this, there would be a need to amend the pleadings. And as I've indicated yesterday, the consequence of that, excluding the fee simple from the map with this particular drafting technique, would amount to the same thing. Fee simple land would still be the subject of what a court would declare. And unless and until the parties agreed to amend those pleadings. But most practically to the member, the map would be extraordinarily difficult to read. It would create the exclusion where we look on the map for the exclusions of fee simple parcels. And I would ask the member to contemplate what the level of detail would be required to show, for example, in Dodge and Geeks or Massett, where those fee simple parcels are. It would have to require extraordinary detail. The scale of the map would be very different than the one contemplated in the bill to do what he has asked us to do. The architecture of this act and this agreement is that Aboriginal title is conferred on, is recognized as existing on Haida Gwaii with the explicit exclusion of fee simple. And I end by simply quoting the former Attorney General for the then BC Liberal government, Mr. Jeff Plant, when he writes as follows, quote, "It would be difficult to be any clearer than this. You don't need to be a lawyer to read plain English. To argue that this agreement somehow threatens fee simple property rights on Haida Gwaii is to misread the agreement. To tell others that this agreement threatens fee simple property rights on Haida Gwaii is to mislead them," close quote. For those reasons, I would be voting against the proposed amendment.
Recognizing the member from Vancouver-Langara.
Thank you, Madam Chair. And the points that are clear in the three amendments that I proposed to the bill are also on the basis that the Minister and I have had significant exchange about the fact or that the coexistence of Aboriginal title with fee simple interests is not a settled area of law, that courts have not engaged to determine that coexistence, and that even in Silcotin, as we've discussed, the private property interests were not the subject matter of the engaged with the final decision of the Supreme Court of Canada in that declaration of title to the Silcotin and Handicatin in that decision, nor was that done in Chalmette as well by a lower court decision here in the province of British Columbia. The reason why, despite what the minister will say and respond to in terms of Mosaic, the focus is not on just the 2.2%. I say that as a point of reference. But it is overall, the overall concern has been around this new model, this new template, and that the way the bill is constructed, the way that this provincial government is approaching recognition of title is a new way. We all agree with that. It's not treaty. It's not a declaration by a court. It is an agreement between this government and a First Nation under an agreement, and now through this bill. So the importance of this amendment is not just for the purpose of the Haida or Mosaic or any other private land interest. It is about the whole architecture, as the word the minister utilizes, as to how this new model is constructed. And so the three amendments I propose, including this one, will make it very clear, for the reasons that we've been talking about at length, about all of the protections that the minister has said, even on first reading and second reading and in committee stage. He has been consistent with that. And as I said at the outset, every time, well, not every time, but having heard several times a former Attorney General of our province, who I have great respect for, Jeff Plant, his point of view, and others have said similar things. I have a difference in view, obviously. I have concerns and considerations about, I understand what the words say, but how does that connect up, both with the interpretation of our jurisprudence, Section 35 jurisprudence, that's referred to here in terms of backstopping Aboriginal title, the Recognition Act itself, the agreement, the fact that the landowners are not part of the agreement, the need for clarity and certainty in the bill itself, the new model and the template going forward. There are other considerations, certainly. But the words themselves on the page, clearly, over 5 days of committee, have been areas of clarification. I have received as much as the minister can provide, recognizing that there still is a 2-year transition period, recognizing that the federal government is not part of this table, or part of the agreement, or this piece of legislation, recognizing that this is an unsettled area of law in terms of the coexistence of Aboriginal title with fee simple interest. So this is the reason why, Madam Chair, in the context of all of the points that we've raised, I only mentioned a few of them just now, that this amendment is done on a basis in good faith to bring clarity to this bill. And it is premised on the workings of where the parties are currently. We know, and this is an area on the first day of committee when we talked about the agreement itself, that it is not a binding agreement at this time. It has not been made effective. The parties still need to go through that process in the summer. With this amendment, there would need to be a further amendment to that agreement. That is for the parties to determine whether they're in a position to do so. We're not a party to that agreement. We only have the role that the official opposition, the BC United, play in all of this is to review the bill. That's all we have here. We asked for a pause on the agreement back on March 22nd, and the Council of Haida Nation clearly representatives came to meet with me in my office before they finalized the agreement and signed the agreement. But I didn't have a copy of the agreement. They weren't in a position to share the agreement with me. Nor was I invited, of course, to be part of the agreement-making process. This is the legislation-making process, and we are now on the back end, let's say, of that committee process for sure. So in terms of the steps that we need to be taken to address the agreement in the face of this amendment, absolutely, I understand that. That is for the government and the Haida Nation to consider. But I would suggest, given that it's not made effective, it's not binding, it's still an agreement that has been signed clearly. But this is the time to be making amendments to a bill for which this government is raising and engaging the honor of the Crown. it will be very difficult for a future government to amend this bill to give the kind of clarity that I am asking for in this amendment. This is the reason why I'm proposing this amendment at this time. Once this bill comes into effect, is enacted by this government, clearly this government has not, in each case, the amendments I've raised for clarity and certainty, including this third one, the minister is indicating that he is voting and not in support of. He's voting against. I know that as we talk about the court proceedings, that two other points. On the court proceedings that continue, my understanding is, of course, that the whole reason for the agreement is not for the court proceedings to continue on fee simple. That the Haida Nation is having their entirety of Aboriginal title and terrestrial lands on Haida Gwaii being recognized. That's the whole point of this. So to the extent that pleadings need to be amended, I believe that those pleadings would already be amended because there is agreement now, through the agreement and through this bill, that that is the case. So, but the other point that the minister raised on the technical point, the Land Title Office has a role to play in the registration of title under the Torin system in our province. There is a clear record of those fee simple interests in the Land Title Office. It is practically possible, of course, to have a printout or an identification, a listing of all the parcel identifier numbers of all the fee simple interests on Haida Gwaii. That is a known thing. In fact, I would suggest to the minister and this government, of course, it has to be. So, because if it's unknown, what is Haida Nation consenting to? What is Haida Nation confirming and continuing if we don't have that list? Of course it exists. It's in the Land Title Office. This amendment is referring to that mechanism, what every person, buyer, seller, banks rely on, for example. So I would have thought the government and the Haida Nation will be relying on this as well. So yes, there is a map. There's a blue line around the map around Haida Gwaii attached to the agreement. It would be attached to that, would have the listing of all the private property rights, the by parcel identifier numbers, PIDs, that would detail out and identify each of those individual pieces of land that are fee simple interests on Haida Gwaii. That's how mechanically you would separate this out. So with that in mind, again, I would encourage members of this committee to consider this amendment and vote in favor of the amendment for the reasons of the clarity and certainty that it would bring to Bill 25.
Seeing no further speakers, the question is on the amendment to Clause 3 of Bill 25. All those in favor, please say aye.
Aye.
Those opposed?
Nay. Division.
Division has been called. Before putting the question, I remember all members that only the members of Section A or their duly appointed substitutes are authorized to vote. The question is on the amendment to Clause 3. Those in favor, please rise or otherwise indicate. Thank you. Thank you. You may be seated. Those opposed, please stand or otherwise indicate. Who's standing? That's not supposed to be here. Routley. Oh, shall I tell them? Thank you. You may be seated. Clerk. Sorry.
Emily Walker,
I vote nay.
those voting aye.
There's another member.
Oh, no,
Oh, she's not on,
voting.
sorry.
She's not voting. Those voting aye, Lee Oakes Bond. Those voting nay, Rankin, Donnelly, Begg, Mercier, Sims, A. Singh, Starchuk, Whiteside, Olson, and Walker, 10.
We'll call back your staff so we can move on to Clause 3. Thank you. On Clause 3, those in favor? Opposed? Carried. So ordered, sorry. On Clause 4.
Madam Chair, so on Clause 4, just reading this against the Agricultural Land Commission Act and what's set out in Section 2 of the Act, this subsection, the amendment, as a consequential amendment to that Act under Bill 25, Clause 4, Madam Chair, suggests that
Members, if you could just keep your comments, your commentary down. Thank you, so we can hear the
Thank you, Madam
member.
Chair. Just in terms of this provision itself, it reads, subsection 1 does not apply in relation to the Haida Nation Recognition Act. And so subsection 1 is subsection 1 of section 2 of the Agricultural Land Commission Act, which says this act and the regulations are not subject to any other enactment. So I just wanted the minister to clarify the purpose of this amendment. Is that in any way contrary to what's been set out in 4.4 sub 2 of Bill 25, meaning enactments of British Columbia in relation to Crown land continue to apply?
Minister.
Thank you. Appreciate the member's question relating to this consequential amendment to the Agricultural Land Commission Act. So just in general terms, the consequential amendment would amend Section 2 of that act to provide for the act to be subject to the law, the bill before us, the Haida Nation Recognition Act. And the point of that is to ensure that the Haida, I'll call it the Haida Act, prevails if there's any conflict or inconsistency between the Agricultural Land Commission Act and the Haida Act. So the new, as amended, the Section 2 of the Agricultural Land Commission Act would read, subsection 1 of that act does not apply in relation to the Haida Nation Recognition Act, and despite Section 3 of this act, the Haida Nation Recognition Act prevails to the extent of any inconsistency. And the point of this is that the act as amended, the Agricultural Land Commission Act as amended, would say this act and the regulations are not subject to any other enactment except these statutes that I've mentioned, because we would amend that to add the Haida Nation Recognition, the Haida Nation Recognition Act. So the member asks a specific question in light of that. And he asks, does this consequential amendment conflict with Section 4.42 of the Haida Nation Recognition Act? And the answer is no. They are consistent. They go to the same place. And perhaps the reason for that is that the definition of owner, the term owner, in the ALC Act includes, sub D, it, quote, in relation to Crown land, the government. In other words, the government is the owner of Crown land, it confirms, and the act, the Agricultural Land Commission Act, applies to agricultural land that may be held by the Crown. So the objective of the consequential amendment is to ensure that there is that consistency. So I believe that Section 4.42 works in harmony with the consequential amendment under discussion.
Member.
Thank you, Madam Chair, and appreciate the Minister's response. And I think the short of it is the language that is set out here is a double negative. Where it says the act is not subject to any other enactment, that negative suggests that that section is not, subsection 1 doesn't apply to the Haida Nation Recognition Act. And for clarity, the Haida Nation Act does prevail to the extent of any conflict or inconsistency with the act itself. So I think that that's where we get to. We're back to the beginning part. Does that mean, though, that where there is recognition of Aboriginal title, that subject to the nature of the bill that might recognize that Aboriginal title, that the Agricultural Land Commission Act would no longer apply? Is that correct? Because the bill that recognizes that title takes prevalence over the Agricultural Land Commission Act.
Minister.
Well, thank you. And to the member, no, I don't think that the way he posed it is correct. I think it's accurate to say that the Agricultural Land Commission continues to act like any other land any other statute relating to land in the two-year minimum, the two-year estimated transition period. And so what that means is the Agricultural Land Commission can still designate Crown land on Haida Gwaii as agricultural land in the period of that is contemplated for the transition. That, I think, is the intent.
Member.
I understand the minister's response. It does raise another question, though, in terms of the nature of the architecture, is the minister's word, and I think it's a good word to utilize in terms of the way the bill and the agreement are constructed to recognize title, Aboriginal title to the Haida Nation. And that is, just as I even look at this wording that the Haida Nation Recognition Act prevails to the extent of any conflict or inconsistency with the Act, the minister in his response referred to, generally speaking, and he can clarify because I was focusing on my question here, I believe he was referring to the transition period as well, that it's to come, that the clarification of jurisdictions, but during that period that would unfold. But that transition period, of course, is called for under the agreement and not under the bill. The bill, of course, talks about interim measures, and that's set out in Clause 2 of the bill. But the actual transfer of jurisdiction responsibility that's enumerated, contemplated under the Transition Act or the agreement itself, the transition schedule to the agreement, is actually not hardwired into this bill itself. So when I look at what prevails, it's the Haida Nation Recognition Act as amended by Bill 25 that prevails. But there's no real clarity as to the transfer of responsibility or jurisdiction. So when we say the Act prevails, what does that refer to in the context of the Agricultural Land Commission Act?
Minister.
Thank you. The issue of the prevailing that the member focuses on, I think, can be clarified as follows. When the statutory decision maker under the Agricultural Land Commission Act is doing what they do, they must take into account the existence of this Recognition Act before us, and that entails the recognition of Aboriginal title.
Member.
And Madam Chair, that response is consistent with the responses of the minister when we're reviewing clauses 4.4, 2, and 3 of the bill itself. So recognizing, of course, the importance of the Agricultural Land Commission and the role that's played there by the ALC on ALR land, what level of consultation, if any, has occurred with the agricultural organizations? Were they part of some of the engagements that the government had relating to Bill 25?
Minister.
Thank you very much, Madam Chair. The member asks what level of consultation occurred with the agricultural community. Well, there's a number of things to say. First, we, of course, consulted internally with the members of the Agricultural Land Commission. The BC Cattlemen's Association, as a province-wide organization, was consulted. But importantly, the agriculture community in Haida Gwaii, which exists but which is relatively small, was invited along with every other member of the community in various letters to come to private, to open public meetings and the like. But I want to reiterate perhaps the most important point, which fee simple land is not affected. And that therefore would have been a full answer to the concerns that if they had any, I'm not aware of any concerns that those local members of the agricultural community might have expressed.
Shall Clause 4 pass? So ordered. Shall Clause 5 pass? On Clause 5, member.
Thank you, Madam Chair. I just looking at the provisions that are set out here relating to the Cheat Act, subsection 6 of 4.2 that is being amended. Can the minister just walk through the reasons why sections 5B little 3 or section 11 of the Act do not apply in this in relation to escheats and forfeitures on Haida Gwaii?
Minister.
Thank you very much, and the member will realize probably better than I just how technical this particular area of the law is, but I'll do my best because not everyone, I'm sure, watching would know what the Escheat Act is all about. And it is a law that allows for the return of lands to the province under ancient process going back to medieval times, but codified in our BC law, whereby land escheats to the province of British Columbia. The Crown takes back fee simple land when, under certain circumstances. The power has that ability. The province, rather, has that ability to take land back, has had that for ages. And that power, in the case of Haida Gwaii, under this amendment, this technical consequential amendment to the Escheat Act, would enable the government to give them the power to return land to the Haida Nation. So maybe just for context, I've asked to see whether we have provincial statistics that would talk about how frequently this happens, either in the province or in Haida Gwaii. It's very, very hard to find that information, but I do have something I can share through you to the member. Almost all of the land that has escheated to the province is a result of a company being dissolved. And that company may have held land on the date of dissolution. The company's gone. A legal person is no longer there. What happens to the land? Well, it escheats to the province. And the province maybe isn't aware of that dissolution, and unless it's contacted for some reason, doesn't know, unless, for example, someone wants to make a claim to the land. To make it even more complicated, companies can apply to have the land restored within 2 years of dissolution. But it does happen that the land disappears and is no longer held and goes back to the Crown. And I asked for statistics on how frequently that occurs. And the last few years, I can report that it sort of varies between 38 and 49 times a year across this entire province. So you can appreciate, Madam Chair, how unusual the circumstance is where a escheat were to occur. But having put that context forward, the members asked a very specific question, I think, about sub 6, 4.2 sub 6 of the Act, the Escheat Act as amended. And that talks about certain sections of the Act not applying in relation to land on Haida Gwaii. And the member asks what those sections would be. Why would we disallow this normal process on Haida Gwaii? And I can answer the question by telling the member that the Act, Section 5 of the Escheat Act, allows the Attorney General to reward a person who discovers the escheat or forfeiture. Well, that's not pertinent. Section 11 talks about the Attorney General having the power to sell escheated land. Well, that's not relevant. And finally, Section 12 talks about disposition powers and selling it and advertising it or causing it to be sold in public auction or the like. Given that the intent is to say in this extraordinarily rare circumstance where land escheats to the Crown, the objective is to give the power to the government to for that land to go to the Haida Nation in those rare circumstances.
Shall Clause 6 pass? No, sorry, Clause 5. Shall Clause 5 pass? So ordered. Shall Clause 6 pass? So ordered. Shall Clause 7 pass? So ordered. Shall Clause 8 pass? Recognizing the member.
I will just wrap my last remaining questions into a three-part question as we're at the end of this bill. So first of all, and then I would like to make a comment when we conclude on this bill. But just in respect of the commencement of the bill itself, or the Act, can the minister, first question, can the minister just walk us through what remains in terms of putting this Act in force? So of course, we've talked about the fact that the agreement, parties need to agree to pick the effective date of the agreement, and then that will be a binding agreement. This Act will come into force, and of course, the minister will, I'm sure, refer to again the important celebration to commemorate this bill and the agreement itself. So if the minister could just comment on that. The second question is that we've had many guests in the gallery here, and one of them has been the special counsel to the Premier, Mr. Doug White. And so as we have talked about at length, Mr. White has been present throughout all of the proceedings. I think it demonstrates, of course, what the Premier has been saying, which is this has been the proudest day of his, I think it's elected life. So, you know, I appreciate that that's one of the reasons, I'm sure, it's a high priority for the Premier and hence the special counsel role that Mr. White plays. But I did want to ask the Minister, just so we understand, what role has Mr. White as the special counsel to the Premier played in the context of this agreement or the bill, or both coming into force as we go? And then the last question, of course, relates back to Dr. Roshan Dinesh. Same question, what role has Dr. Dinesh played in any way in respect of the agreement that has come to pass between the Haida Nation and the province, or this bill itself?
Minister.
Yes, on Clause 8, which talks of the bill coming into force by regulation, cabinet regulation, the member asks about that clause first of all, and I can report that the objective is, as I mentioned in earlier commentary, is for the agreement and the bill to come into force at the same time, to coordinate that coming into force so that there's not any gap between those. And secondly, he asked about what kind of work is entailed in this process. And obviously, the key work is to ensure that public servants on Haida Gwaii and in Victoria and everyone is aware of this change and what it means. And so there'll be no doubt a considerable amount of engagement with them to ensure that they're aware of it. I expect that the Management Council in Haida Gwaii, which has so effectively engaged the members of the Haida Nation, and the province representatives there would be very much engaged, given the work that they're going to undertake in the future. But that kind of implementation preparation, I think, will not surprise the member, will be required before any implementation or is occurring. The member asked then about two lawyers and what roles they played, Mr. Dinesh and Doug White, who's with us. I should say that they were part of a team. And I want to acknowledge to my left Becky Black of the Ministry of the Attorney General, who's just been an extraordinary support for this work, and has worked with Dr. Dinesh, who has provided negotiation support to my ministry and provided advice, including on the best approach to not only the agreement but to the act, to help us, along with Mr. White, who also played a very crucial role in ensuring that the approach that we take, the architecture, as I've used that phrase before, would be such that the Council of the Haida Nation and the province could find a place where they could come together and support this initiative. That was not an easy task, and Ms. Black, Dr. Dinesh, and Mr. White have played an absolutely fundamental role in getting us to this historic place. I'm very proud of all of the team, including the three people that I've mentioned, and many, many more. Heinz Dick, who's with me, who has been absolutely a rock in the negotiation process. These people need to be celebrated for what they've achieved for British Columbia.
Member.
And Madam Chair, this is just a comment, not a question, but it will be my last point that I'll make on this bill. And obviously, we've had the full statements made on behalf of the official opposition about the concerns and considerations. We saw that under the amendments that we have put forward that have been turned down by this government. But the comment I just wanted to end on, because I think it's all out there, hopefully, with a statement that has also been issued today as a result of the non-passage of the amendments and all of that. It's more of a personal note just to the minister. This will be the last time that, at least in this current legislative session, that we'll have this level of engagement. I think that despite all of the challenges, which are both outside and inside the chamber, the noise that I talked about on first reading that was misinterpreted at times, these are the considerations, but I know that the minister has always been answering my questions on behalf of the official opposition to the best of his abilities, and he knows that I have a high degree of respect for his style, his approach over the last 2 years, and I just wanted to say that on the record at the conclusion of this bill debate.
Recognizing the House Leader of the third party.
Thank you, Madam Chair. We get to the end of this this debate, and I appreciate the exchange and have had the benefit of being able to witness it. I feel that this is a good functioning process in which the bill goes through clause by clause, and there's time and space being given to be able to do that. And I feel that this bill has had substantive canvassing. We're at the end of a long road for our relatives in Haida Gwaii and for Indigenous people. We're at the end of a road, and we're at the beginning of another road. And ends up being an emotional day for me today, and for I think many people. But I just say that it's wonderful to see a government, the legislative and executive branches, following what the judicial branches of governments have been saying for decades, and that is find a way to do the business in here and not the business in front of judges and courts. Find a way to create a container for us to be able to fill through a coherent, mature, respectful way. Let's not create a container that's kind of opaque and doesn't really have a lot of detail to it. But let's create let's do this in a coherent, let's do this in a thoughtful, responsible way. Is it going to be perfect? Well, we'll find out. Is it going to be challenging? Well, we'll find out. That's part of the next steps of the journey. But it's really good to see, for the first time in this country, the executive, under the Premier and the Minister, the executive branch, all of the cabinet ministers that have been in this debate or been witness of this debate, this is a tribute to you. And your stick-to-itiveness, your commitment to reconciliation, your commitment to doing it where the judicial branch has asked us as mature governing bodies, democratic institutions, to do this work in here. And so to the executive and to the minister who's handled this, the staff, the advisors, the secretariat, a team of people who have seized the opportunity that is in front of them to take care of what has been described here as probably the least complex piece of land in the province to do this in. It's much more difficult over the rest of British Columbia to do this work. And as someone who comes from Satanage, where all of our land has been leveled and then built upon, the pathway is a bit more challenging, more fraught. I can imagine the debate for that one would be weeks and weeks and weeks on end about all of the attempts to try to extinguish Aboriginal title through private property, and I can just imagine what that would look like. But what this does is it lays out a pathway for communities to come together, sort out their boundaries, sort out their differences, and engage a government in a process. And so what's happened here is that process is a new process, not just litigation, but Aboriginal title through agreement. Shouldn't be something that we're so excited about. It should just be a basic thing that we do. We sign agreements with lots of organizations and institutions and different governing bodies. We have lots of agreements. There's lots of relationships between Crown and other levels of government. But what this is an example of here and what it lays out for other nations across the province is a pathway. Unite, work with your neighbors, and come to the table. And I raise my hands to you, Minister, for creating that opportunity for all Indigenous people.
Recognizing the Minister.
Well, it's very, very hard to not be equally emotional. The Premier spoke about how historic this was and what an accomplishment it has been for his career. I feel equally fortunate to have had a role to play. I raise my hands to the member for Saanich North and the islands because no one knows more about what he's speaking about than someone like him. I've spent perhaps 45 years going to Haida Gwaii. It is a very special part of the world. And what we've managed to do here together needs to be saluted. I don't know Dr. Cheryl Lightfoot, but I know that she is the Vice Chair and a member of the UN Expert Mechanism on the Rights of Indigenous People and Canada Research Chair in Global Indigenous Rights and political science professor. She wrote an article that was very touching. It was in the paper the other day. Some of you may have seen it, Madam Chair, basically saying this agreement leads the way for the world. It is just such an historic opportunity. I want to say to the member to Vancouver-Langara, I suspect his skills in debate and in statutory interpretation are a direct result of his tutelage by Professor John Kilcoyne, who I intend to call immediately after this is over. But in all fairness, I want to just salute the member for his role in this debate. Not everyone understands the role of a critic and reasoned debate in this place. I spent 7 years in opposition. I know what that role is. I tried to do it to the best of my ability, and I think the member needs to be saluted for taking the path that he's taken, a respectful, reasoned debate on a bill that is, we say, a orderly transition to a better place. The member has indicated it's a bold step. Whichever characterization proves to be true is really not relevant. What we have before us is something that we've created together. I want to say that I was not here when the Declaration on the Rights of Indigenous Peoples Act was passed. But I know that the member and the member for Abbotsford West, who is also leaving this place, played an extraordinarily important role. And they asked the same piercing questions, because I answered every word of it when I took on this role. And I can tell you that they did a thorough assessment of that bill as an opposition properly would. But I'm hoping that in this case as well, that after careful deliberation and knowing where we are going as a country and as a province, and in recognition of what the courts have asked us to do, that the member will see fit with the official opposition to do what they did then and bring themselves to support this historic work on Haida Gwaii. Reconciliation requires us all working together. My hope is that we can do so in this context as well. It's been an absolute honor to be part of this debate. I commend it to the entire Legislative Assembly. I hope it achieves unanimous support. I know how historic this is for the people of Haida Gwaii. I'm just so pleased to have had a role in this debate. Thank you.
Shall Clause 8 pass? Aye. So ordered. Just want to recognize, having sat through the debate, is the representative for the Haida Nation. He's been introduced, but I just wanted to recognize that without voice, he's been here, and hope that this has served him well. Recognizing the, shall the title pass? Aye. So ordered. Recognizing the minister.
Chair, I move that the committee rise and report the bill complete without amendment.
Members, you have heard the question. All those in favor? Aye. Those opposed? The motion is carried. This committee stands adjourned.